Good morning, Mr. Raju. This is Arnab here.
Very good morning. Thank you.
Many congratulations because you've been the person behind this.
Good morning, Arnab. How are you?
Very well, sir. Very well. Thank you for joining us, sir. This big morning, big decision. How are you viewing the judgment, sir? You worked so hard on this.
I heard what the learned judge pronounced in the court, and I found the judgment to be very well written, very well articulated, and the learned judge has considered all the points, legal as well as factual points, and given a very balanced judgment. And I have to look at the reasons why the other 6 have been granted bail. Other accused have been granted bail. And I will comment only after I see the judgment. Maybe as far as the role is concerned, the learned judges must have felt that their role is slightly different or different as far as Sharjeel Imam and Umar Khalid are concerned.
The basic argument that was put here by the defendants, Mr. Raju, the fundamental argument is that the trial has gone on for too long. The court has said that that does not make it a case for bail. They've looked at the severity of the offence itself.
The law, Arnab, is not that delay by itself entitles you to bail. But in this case, we were able to demonstrate that the delay, if any, was caused mainly by the accused. The accused, if they are responsible for the delay, then they can't have benefit of their own wrong. So there is a judgment of the Delhi High Court which said that as far as the trial in this case is concerned, the delay is mainly attributable to the accused, and therefore that must have gone a long way in rendering judgment as far as delay is concerned. We had demonstrated the number of times the accused did not argue the matter, the number of times they sought adjournments, and delay, if any, was attributable mainly to the accused.
Why was that the case? What was their
So
strategy? Why was delay part of their strategy? If you see the number of times they were trying to get this whole thing adjourned, what was the strategy behind delaying it? How was that benefiting their own client?
See, as far as delay is concerned, there are 2 aspects to it. Number 1 is that you delay the trial, so ultimate verdict is delayed. Number 2, you are confident or you are aware of the fact that you may not get bail on merits because of merits you have a hopeless case. Therefore, what do? You delay the trial and then say, forget the merits, look at the delay, there is no fair trial, grant us bail. That seems to be the tactic.
What is the larger message sent out, sir, to all the people who are behind this? Let's go beyond the technicalities. If you look at this case per se, what is the larger message sent out today to people who may have incendiary intent, who may want to go against the state, who may want to, create a situation of anarchy, because that seems to be the toolkit of a lot of people who don't believe in the electoral system?
You're right. The message that has come out, which is loud and clear, is you will have to pay for your crime, especially when you're anti-national. If you're a terrorist, you can't expect the courts to lean in your favor. You have to face the music, and it will be difficult for you to get bail. Therefore, it is better not to indulge in terrorist activities and then delay the proceedings and then ask for bail. All right, what happens? I've indulged in anti-national activities, I've indulged in terrorist activities, I'll wait for 3 years, 5 years, I'll come out. The trial will be delayed, we'll delay the trial. That sort of thing has been plugged by this judgment.
Do you think it also sends message out to others who turn agitations into an opportunity to block the streets, impair the democratic process, question governance? In that sense, was that also, in your view, the intent of this judgment?
I'll tell you, Arnab, the intent of this so-called agitation, I will not call it an agitation, it was an operation for regime change. They felt that they did. Our case is, I'm telling you from papers, our case is that these people failed to get a mass movement started in case of Babri Masjid and other incidents. So they felt that this was their chance to have a mass movement, something like Bangladesh or something, and there would be a regime change. Our specific case is that this was not a simple agitation against CAA. It was the entire purpose was to have a regime change. And that was the purpose. All the CAA and the poor people were hoodwinked, and they were sought to be made victims by asking them to participate without realizing what the actual motive and intention was. To some extent, I must tell you, Arnab, the fact that American lawmakers have supported the bail gives some credence. I may not say 100% that maybe this so-called regime change was engineered from outside. I'm not making any allegations. I'm only guessing. It's in the realm of suspicion. Otherwise, why would American lawmakers be interested in a case in India? There are so many other cases, hundreds of cases. Why they have not said anything about any other case? And they have not read the judgment. They have not read the earlier judgment of the High Court. They have not read the case papers. They have not seen the evidence. They don't know what the Indian law is. Indian law is totally different from the English or American law as far as terrorist activities are concerned. And straight away they issue a statement that to give him a bail. Asking the court to deliver a particular type of judgment, according to me, amounts to contempt, amounts to interference with the administration of justice. If these people were in India, probably they would have been hauled up for contempt.
Yeah, I mean, they have spread this canard.
Yes, sir.
Over the last few days, they've spread this canard, Mr. Raju, especially internationally, Mamdani, 10 US lawmakers, that there's been no legal process. These poor chaps have got no legal support. They've not been through a trial. They are being incarcerated without trial. That's been their core attempt. I find it very interesting what you say there, that this is not, therefore, this proves the case, doesn't it? That this is not innocent. You have described Umar Khalid and Sharjeel Imam as the intellectual architects of the conspiracy. But the problem with these people is, you also say those projected as intellectuals are more dangerous because they guide and direct others. But they also keep a sliver of deniability.
Yes.
They keep a sliver of deniability. They won't actually go and burn a car, but they will incite other people to burn a car, to block the roads. So, they've always got this sliver of deniability. They've always got this way in which they can guide a riot and then get away at the last minute. So, you think this judgment will stop any further such attempts?
Yes, it will go a long way in stopping such attempts, Arnab, and it will reveal to those potential terrorists who are waiting in the wings to refrain from such activities, feeling that they may not get bail, and even persons who were victims, not victims who were killed, but victims who are misguided into taking part in the agitation will also be now feel wary about it, and they will also keep their hands off. This is what I feel.
But then at the same time, you've separated the role. You've separated the role from in this case, from Umar Khalid, isn't it, Rhythm? Umar Khalid and Sharjeel Imam have been put in one category, and 5 others have been put in another category. Why is that?
Yes, I think the main reason for that is because their role was more severe.
I'll tell.
Yes, yes, go ahead, Mr.
Go ahead, sir, please.
Go ahead.
They are the masterminds. So masterminds stand on a different footing. And their role, see, in UAPA offenses, we have to show the role. We have to show that the prima facie case is made out. Even these courts have said, even if a prima facie case is made out, if there is delay, we'll ignore the prima facie case and grant them bail. That is what the law is, because that violates Article 21. But where the role is severe, the courts have felt that the role of these two persons are totally different. The roles are severe, and therefore they have to be treated separately. That is what I feel. I have not read the judgment, but I'll come back on this after I go through the judgment.
But you also said that Umar Khalid particularly, Umar Khalid, you know, Mr. Raju, I had played a role in exposing the JNU tukde-tukde gang. This was, by the way, you know, a hashtag that I coined at that time, tukde-tukde gang. Umar Khalid is interesting because he was the person who delivered that Bharat tere tukde honge slogan, but he's denied it all the time. He's denied it. He's become more cautious. He tried to be careful. So what is his mentality that you see of Umar Khalid here, sir, and his role?
See, nowadays, a trend has emerged where the masterminds try to cover the tract and see that there is no evidence which is there which can pinpoint to them. But the Delhi police have done a wonderful job. They pointed out everything. They pointed out regarding his speeches, etc. I'll tell you why Umar Khalid and Sharjeel Imam are dangerous. They are not ordinary persons who orchestrated a simple agitation or a protest. These are the persons who said, cut off Assam from India. Cut off Assam from India, break chicken neck. How can you say that these persons are ordinary terrorists? They are the worst type of terrorists who want to dismember India and divide India into parts. And Umar Khalid is instrumental in supporting the cause of India, tumhare tukde-tukde, Bharat tumhare tukde-tukde honge. How can these persons be given the same treatment as far as bail is concerned as compared to other maybe terrorists who have undergone 5-7 years, but they've done one act of terrorism. I'm not saying that they are not terrorists. They still deserve a harsh treatment, but they have to be treated slightly different in the matter of bail, not in the matter of grant of sentence or imposing of sentence.
So I just want to have one question on the wider web, and then I'll hand over to Rhythm. Mr. Raju, my concern is always of the wider web. As you have rightly pointed out, there is a wider web, and in my view, the wider web also includes political parties, political personalities who played a role behind them. So we can't really be sure who the mastermind is. The mastermind could also be political. What about the role of political parties in encouraging these kind of people? You know, what becomes their role? There were a lot of people involved. There were question marks raised. There was a meeting where Yogendra Yadav was also present and other so-called political activists were present. I'm sure you've seen the picture of the meeting during the CA protest where these people are sitting together and planning.
I've seen the picture.
What about that?
But Arnab, it is essentially, I'll tell you, it is essentially a role of the police. It is for the police to find out or fathom the evidence against these persons. Supposing whosoever he is, he may be a leader in a political party, but if there is evidence, I'm sure the Delhi police would have gone after him. The fact that they have not been named and accused, today there doesn't seem to be any evidence to charge sheet them. But tomorrow, if they find that there is some evidence, they were instrumental, their intention was not simply remain present in a meeting, then definitely Delhi police still is investigating into certain aspects, they'll go after it. But today, according to me, there is no evidence, and I can't comment on an investigator's role.
Absolutely. Rhythm has a question for you, Mr. Raju. Yeah.
Mr. Raju, we've also seen when this case was going on, you spoke about two things that I remember. You spoke about whenever the case is coming, a New York Times will write a sympathetic article on Umar Khalid and they don't realize he's an anti-national. Not only him, but also this 7-8 minute video that was given by the Delhi police played in the Supreme Court where Sharjeel Imam also tries to show anything and everything that can mobilize a certain community, where he says, court ko nani yaad dila denge. It's very clear they wanted any excuse to try and mobilize a community. And one other thing, this was not only about Delhi and essential services in Delhi, which the Supreme Court spoke about as being an essential part of UAPA charges. This was pan-India. The affidavit also speaks about Uttar Pradesh, where there was widespread violence breaking out in 20 districts. In Assam, violence was there in Guwahati, Dirbhunga, Kamurup. And in West Bengal, it was there in Murshidabad, Howrah, Malda. The question that I'm only asking is, if it was pan-India, it is no longer only related, sir, to Delhi, then there should be a harsher punishment and they should be called out as what they are, terrorists.
See, Rhythm, the issue is their intention was to create a movement pan-India. They did not succeed. Okay. So the intention is pan-India. Whether it is pan-India, whether it is Delhi, whether it is restricted to cutting of Assam from India, it is all a terrorist activity. So terrorist activity, whether it is pan-India, whether it is only restricted to Assam or Delhi, is a terrorist activity. So you will be punished. You are right. At the stage of granting of punishment, deciding what punishment is to be given, at that stage, this might be a necessary or a vital consideration.
I think the point that you are making, which is very important for everyone, Mr. Raju, is that this was a pre-Bangladesh, pre-Nepal operation with the same intent, a pan-India change of regime with global backing. This was not happening locally. It was deep-rooted, meditated, pre-planned, hatched by these people. But, and this is my final question to you, Mr. Raju, it resulted in the death of 53 people. Right? So consequentially...
And 530 were injured.
And 530 were injured, including policemen and police women, if I may add, sir. So...
Yes, IB officers.
Yeah, so you had told this court, what I really liked about your arguments and the way you were presenting it is that you see, Rhythm, Mr. Raju was broad-basing it. He was talking about regime change. He used the word economic strangulation and he talked about engineering communal rights. So he spoke about a triad of circumstances. CA was a facade in his view. Am I right, Mr. Raju? CA was the facade. The intention was something completely different.
Right.
So what is the punishment they could face now? Court is taking a clear stance on this.
The maximum punishment under the UAPA is death or life for the offences which they've. So the offence could be maximum is death.
Well, Mr. Raju, I would like to congratulate you again. I think Rhythm and I have followed what you've done here. And I think this will have long-term consequences. I thank you very much for joining us. Thank you, Mr. Raju, and congratulations once again, sir.
Thank you, Arnab. Thank you, Rhythm.
Okay, Rhythm, I think, I just want to add a point here before I move on. And, the fundamental thing, the way I'm looking at this judgment, this is my first comment on it, is that I have been talking for the last 10 years about the tukde-tukde gang. It has taken now 10 years for Umar Khalid's, goose to be cooked, as it were. But fundamentally, people like Umar Khalid were thinking that they would provoke a situation, then project themselves as intellectuals and seem to be quote-unquote a guiding force who at any point of time automatically step away and say, I'm not responsible for the consequences. You are responsible for creating the reason why the protests happen. What is clear here, Rhythm, is that these are not protests. These are regime change operations. We've made the mistake every time. Every protest we see as protest. And the important lesson for the government is not to give in.